Hello everyone, Alan Donald here with Keller Williams Realty, and today we have a guest of honor, Aashini. Aashini is an estate attorney, and she comes to talk to us about wills, estate planning, how to plan ahead for the future to keep ahead of the curve in terms of asset management and everything else that you need to plan for when you start getting older. Welcome, Aashini.
Thank you so much, Alan. Thanks for having me here.
Tell us a little bit about yourself and your background.
Absolutely. Thank you for having me here, Alan. I'm Aashini Shrivastav. I'm the owner and lead attorney at Cardinal Wills. It's a mobile estate planning service that I started a few months ago, where I go to people to complete their simple estate plans. So I've been doing estate planning for about 4 years now, and this is my first journey with myself.
So mobile estate planning, that's a different gist to it. What made you choose that line of work?
Yeah, so in my last job, I noticed there were a lot of people that needed convenient services, whether it was at their home, their hospital, a nursing home. This was applicable to seniors, but also to young families with children where they just needed some convenience. So when I was brainstorming what would be a good idea for my own business, I knew that that's what I love to do. And I loved having people work with me to attain that peace of mind for what they want to do with their assets in the future. So that's where Cardinal Wills was born.
Oh, fantastic. So I'm going to ask Aashini a few questions. These are the most common questions that she gets asked by her clients, and hopefully her answers will help you and your family plan ahead. To start with, Aashini, what is an estate plan?
So, Alan, we got to take the word estate. So everybody knows what a plan is. A plan is a blueprint for at some point in the future, right? So estate, when somebody passes away, all of their belongings, whether it's their real estate, their financial accounts, their personal items like clothes, shoes, books, all of the items that are in their name go into this metaphorical bucket, this imaginary bucket called an estate. So their estate is what is being dealt with after somebody passes away.
Okay.
And so all of their assets are put into this estate, and having a plan for it is you deciding what you want to happen with all of your belongings after you pass away.
So basically you control it from when you're alive and after you pass.
Absolutely. And estate plan, you know, a lot of people think about it for just when you pass away, but there's also another component for when you are no longer able to make your own decisions. So when you're a healthy, fit human being, you can make all of your decisions with finances and healthcare, but unfortunately, we know from so many other people's experiences that this is not always the case. Whether a tragedy happens and you're no longer able to control your own affairs, it is good planning to assign someone to manage your affairs for you and to make these healthcare decisions for when you are no longer able to.
And that dovetails precisely with our goal as seniors real estate specialists. We want to help seniors and their adult children plan by design and not by emergency.
Absolutely. The idea is that by everybody having an estate plan, they are making rational decisions in a time of calm as opposed to making urgent and rushed decisions.
Fantastic. All right, Aashini, let's say I'm not rich. Why do I need an estate plan?
There is this misconception that only if you're rich do you need an estate plan. But here's the thing. Everybody owns items in their names, whether that's vehicles, whether that's weapons, whether that's real estate, and also your children, your minor children under the age of 18 are under your care when you're alive, right? So even if you do not have a high net worth and you do not have 500 properties and you do not have many vehicles, you should still have an estate plan because you get to direct what you want to happen with your assets after you're gone. Whether that's who gets your vehicles or who gets the guardianship of your minor child. That is a really important thing that all young families should think about.
Yeah, that makes a lot of sense. I'm just a normal person. When will I need a trust or a will?
Yeah, so a will, I recommend to people that if they have real estate in their name, vehicles in their name, or minor children, a will is the bare minimum they should be thinking about. In South Carolina, it's really important to have a will for those three purposes so that the probate process, so probate is the transfer of assets from a deceased person's name to a living person's name. So probate is the process that happens after you pass away. So if you have a will laying out what you want to happen with your vehicles, your real estate, and the guardianship of your children, it'll go much easier during the probate process. If somebody has high net worth of assets, a lot of LLCs in their name, a lot of properties in different states across the world, that is when they should start thinking about a trust, because that's when tax implications come into play. The reason someone should consider a trust is if they have a lot of businesses in their name, a lot of real estate spread out across different states, different countries even, and if they want to decide to divide those assets in a different way, whether it's 2 properties to 1 child, 1 property to an LLC, and divide it in a very different manner, a trust would be a good idea for them at that point. Okay. So will is very much the basic level of estate planning, and a trust is as you get more advanced and as you have more net worth.
Oh, that makes sense. So Aashini, in real estate, we get a lot of people that say, wait, I have my house as joint tenants with right of survivorship. I don't need a will. Yep. If I pass away, the house will be automatically deeded to my wife. Why would they need a will?
So we know that unfortunate accidents happen all the time where multiple people pass away at the same time. So yes, you're right. If one person passes away, automatically the real estate goes to the surviving person listed on the deed. But God forbid, if both people were to pass on, there should be a plan in place. And we don't know who goes when. A lot of people are not thinking about estate planning all the time. It would be wonderful if people thought about it once a year, but the reality is that people only think about estate planning once every 5 years, once every 10 years.
Or with something happening.
Exactly, when there's a crisis. And so it's good to have a plan in place, because you may forget later down the road to go in and update your will after somebody passes away. So having both people listed on the deed should have an estate plan just in case the worst happens. It's all about just having a plan for peace of mind. And I truly believe that estate planning is an act of love. It's an act of love for your family members, for your loved ones, your friends even. And it's just helping them go through a challenging time, because an estate plan really comes into effect when either something has happened to you or you are no longer around. Your family and friends are already going through such a challenging time with grief or navigating difficult emotions, so having everything written out just helps them out.
So Aashini, we were talking about estate planning and wills. How often or when should people update their estate plan?
That's a really good question, Alan. So I tell people that when something life-changing happens, so that could be a marriage, that could be a divorce, that could be having grandchildren, new people that you want to add into your estate plan, that could be some drama where you need to write out people from your estate plan. You know, that happens. And so I tell people when life-changing events happen, always review your estate plan. It is good practice every 3 to 5 years to just lay eyes on your plan. This also includes reviewing beneficiaries on your bank accounts, on your 401ks, your investment accounts, anything that's a financial account. It's good practice to review your beneficiaries and make sure the money is being distributed how you want it to be.
So for example, if I have a bank account where I have a lot of money, why can't I just have one of my children be a signatory?
You can, but what happens if, God forbid, you were to pass on and then your child does not have any beneficiary listed after that? So it's a good practice. So even if there are 2 account holders on the same bank account, it's always good practice to have a beneficiary listed, just in case, like I said, the worst happens.
What happens if I become personally incapacitated?
Absolutely. This is a very common question that I am asked. One of the documents in simple estate planning is called a durable power of attorney. This document, you are assigning someone to be an agent for you to handle your finances. Of course, there's more nuances in the document, but that is the gist of it. You're assigning someone to act as if they were you with respect to, signing mortgages, deeds, managing bank accounts, handling a safety deposit box, handling Social Security, and things like that. Having a durable power of attorney means that when you are deemed to be incapacitated by a medical team, that person that you've listed as an agent can continue to act on your behalf for your best interest. They can't go rogue and do whatever they want to. They have to do things in your best interest.
Like fiduciary.
Like a fiduciary, exactly.
Okay.
So they have to act for your best interest, and they can sign documents and manage accounts and close accounts for you. So if you are mentally incapacitated and you have a durable power of attorney, that is a good way forward where somebody can handle your finances for you. If you do not have a durable power of attorney, the person, family member, spouse, adult child who wants to handle things for you will have to go through a guardianship and conservatorship process through the courts. This will usually require an attorney, and it does take significantly longer than just getting a durable power of attorney drafted. This document can only be done when you are of sound mind.
So what's the difference between a durable power of attorney and a healthcare power of attorney?
Yeah, so a durable power of attorney is for when you are incapacitated and you cannot handle your own finances. A healthcare power of attorney is for when you can no longer make your healthcare decisions. So, when you're engaging with a doctor or a medical team, or you're in a hospital for any type of situation, you can say what you want, what you don't want, what medication, you don't want to be on. You can consent or refuse any types of procedures. If you are deemed mentally incapacitated, you can no longer express your healthcare desires. In that situation, if you have a healthcare power of attorney, that agent can then talk to your medical team on your behalf and say, this is what this person would have wanted, this is what this person would not have wanted. In the healthcare power of attorney, there are several sections where you can state your beliefs on artificial respiration, artificial nutrition, organ donation. If you have any religious or spiritual beliefs that you want to be considered, you can write that in there. So you're not leaving your agent completely blind. Your agent will make decisions for you in accordance with everything else that's already listed. This is not dinner table conversation for most people, so it can be difficult for people to think about these situations. Of course, it's a difficult time to think about this, but if you plan ahead, you are giving that agent peace of mind so that they know, okay, this is what this person would have wanted. I am following their wishes. I am free of any emotional guilt.
Right. Because these topics are difficult for families to discuss, because the parents don't want to involve the kids because they have their own life. They don't want to burden them. Yep. The kids, they want to talk to the parents because they feel they're encroaching on their life. So it's an uncomfortable conversation, but it's some conversations that need to happen to be able to plan ahead. Right?
Absolutely. And the difficult thing is that if you do not have a healthcare power of attorney, every state has its laws of who is next of kin. Mm-hmm. So of course that could be a spouse. If there's no spouse, it would be children. Now, which child? So if children start disagreeing on what to do with their parents' healthcare, that could lead to some very, very difficult situations. And the medical team is not going to sit there and mediate adult children fighting over, would dad want this or would mom want that? So it's wise to just have a plan and appoint these agents so that everybody knows, okay, this is going to be the decision maker. No need to fight. Already it's a challenging time emotions-wise. Right. And people start to bring their own emotions into it, and so it can really muddy the waters about what would this person want. Absolutely. So having this document makes everything a lot easier.
Makes a lot of sense. Thank you. Aashini, we're in the age of AI now. With all the AI and digital things happen, how do you include or manage digital assets using estate planning?
Yeah, so in a last will and testament, there is a paragraph where your personal representative or executor of the will has the authority to go in and handle your accounts, any accounts in your name, whether that's email, social media, cryptocurrency accounts, things like that. They can handle those accounts and close them down. In this day and age, there are companies like Meta and Google that have thought about this. So with Meta, you can assign a legacy contact so that when you are no longer with us on this planet, Meta will notify your legacy contact and they will have access to your account. They can memorialize it so that you do not continue to live in a digital sphere. Google has a similar situation where they have an account manager where if your email account goes inactive for about 3 to 6 months, then they will notify this next person and give them access to the login so that they can now go in and close that account down.
Right. Oh, that makes sense.
So there are companies that are thinking about this and trying to make it easier for people so that they can plan, but these are all types of things that I know I discuss with my clients, and I also know that other attorneys do the same.
Well, Aashini, this has been so useful and educating for me. I hope that it was a educational experience for you as well. And if people want to reach you, how they can best reach you?
They can reach me in a variety of ways. I think the easiest would be my website. It's www.cardinal-wills.com. You may email, by phone, by text, by Facebook message.
We'll put all that contact information.
All of that's good. So I will reach out. I go out on a limb and I tell people that Cardinal Wills is affordable, convenient, and dependable. So I will get back to people at most in 48 hours.
Thank you so much, Aashini.
Thank you,
the Alan Donald team, we are seniors real estate specialists, and we like to be the connectors for all of you who are thinking about transitioning homes, planning estates, and we have the contacts to set you up with in the legal, financial, logistics, and of course in the real estate area. This is Alan. Until the next one.